Welcome to my channel where we discuss everything and all things politics, especially about the 2023 presidential election held in Nigeria on February 25, 2023, and the result announced on March 1st, 2023. And that result is being challenged at the Court of Appeal or the Presidential Election Petition Tribunal by, most importantly, Labour Party presidential candidate Peter Obi, who many Nigerians believe will bring the kind of change that the country needs if the election had been free and fair. And if that election that was not free and fair that is being challenged in the courts. And in this video, we're going to look at the issue of 25% of votes cast in the Federal Capital Territory, Abuja, through the eyes of Peter Obi's lawyers. Now, I have discussed this particular issue in some occasions in this channel, but in this video, we're going to look at it through the eyes of Peter Obi's lawyers in their final written address submitted to the Presidential Election Petition Tribunal. And we are going to see how Peter Obi and his lawyers address the vexed issue of getting 25% in the Federal Capital Territory, Abuja, whether it is mandatory or not, through their eyes. And then we'll see how they interpreted Section 299 of the 1999 Constitution, which the lawyers of Asiwaju, Bola, Ahmed, Tinubu, and the APC and INEC are using to challenge Abuja, to challenge the fact that the Constitution requires that you must get 25% of the vote cast in Abuja for you to be declared the president of the country. And that particular section we are talking about is Section 134, subsection 2B, which states that in any election in which there are two or more candidates, for any candidate to be declared the winner of the election, the person must first get the highest number of votes cast in the election. The person must have 25% of the vote cast in 2/3 of the 36 states of the Federation and the Federal Capital Territory, Abuja. That "and" is the subject of discussion, is the subject of dispute. Is that "and" compulsory that you must get 25% in Abuja before you can be declared president? Or are we to agree with the position of Tinubu, the APC, and the Independent National Electoral Commission that "and" that Abuja is not compulsory that you must get 25% in it, and that Abuja is not distinct from the 36 states of the Federation, that indeed Abuja could be classified as 37th state of the Federation? They used to cite Section 299, which talk about Abuja being treated as if it were one of the states, or being treated as if it were a state. Now we're going to look at the presentation of Peter Obi and his lawyers. And I'm particularly excited because the lawyers did a good job in showing that 25% is compulsory and that you cannot use Section 299 of the Constitution to settle the matter that the Constitution, the framers of the Constitution, put in Section 134, subsection 2B. They were able to prove it convincingly. So we're going to look at it from their perspective, because then we'll be able to get idea where they are coming from and why it is important that they do a good case, because this particular issue is enough to nullify the election of Asiwaju Bola Tinubu, who could not get up to 25% of the vote cast in Abuja, based on the results as announced by INEC. Now, the lawyers of Peter Obi started by looking at the literal interpretation of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria, 1999, as amended. They noted that it is strict law that the word "and," as used in Section 134, subsection 2B of the Constitution, is conjunctive. It is conjunctive, meaning that it is compulsion. Like somebody saying, for you to be able to be allowed to get admission in a university to study business administration, that you must get credit. You must have 5 credits with maths and English compulsory. Even if you score A's in all the other subjects that you did and you didn't get maths and English, no university will take you. That's facts. Because maths and English, conjunctive, you can't get one without the other. Now, in their presentation, final written presentation, they took note of that. They reminded the justices that it is strict law that the word "and," as used in Section 134, subsection 2B of the Constitution, is conjunctive. They said that the word "and" has been given judicial interpretation in a litany of cases. There are several cases where the word "and" had been settled to define what it is. They cited the case of Abubakar versus Yaradua. That's Atiku Abubakar versus Yaradua in 2008. Okay? Now, Section 134, subsection 2B of the 1999 Constitution, they say is clear as crystal and unambiguous, direct and simple. Basically, what the lawyers are saying here is true. That section is unambiguous. Any child who can read English language, who can read and understand English language, or read and comprehend English language, will know that "and" in that section of the Constitution is conjunctive. That "and" is so simple that it's self-explanatory. So they were right in saying that it's clear as crystal, unambiguous, direct, and simple. They noted that the language of the Constitution is clearly to the effect that a candidate to be declared a winner of the presidential election, that candidate must secure at least 1/4, that's 25%, of the vote cast in 2/3 of the entire 36 states of the Federation, that is 24 states. And again, that candidate must also not get less than 25% of the votes cast in the Federal Capital Territory, Abuja. That's what they presented. They say, my lords, the literal interpretation of this section is that a candidate must secure 1/4, that's 25% of the vote cast in 2/3 of the entire 36 states of Nigeria, and 1/4, 25% of the votes cast in the Federal Capital Territory. The lawyers of Peter Obi went on to explain that the use of the word "and" had been held by the Supreme Court to be conjunctive, which implies that the conditions in section 134, subsection 2b are conjunctive and mandatory. This issue have been addressed by the Supreme Court in 2008. Even the former Attorney General and Minister of Justice, Michael Andwaka, Senior Advocate of Nigeria, who was the Attorney General of the Federation under Yaradua, President Yaradua, when that issue was brought up in 2008, said that the Supreme Court settled the matter and said that it was conjunctive. So in that case, it is compulsory, it is mandatory that you must get 25% in Abuja. So the Supreme Court have settled this matter. And they have already, the Peter Obi's lawyers, they also cited that particular matter. Now, after saying this, the Peter Obi and his lawyers, they now move to the next level to look at the judicial decisions on section 134. That is the one that talk about that for anyone to become the president of Nigeria, the person must get 25% in 2/3 of the 36 states of the Federation and the Federal Capital Territory, Abuja. And then section 299. This section 299 is talking about, is where the Constitution said that Abuja should be treated as if it were one of the states, as if it's a state. Because that is what they are arguing, what Tinubu and co are using to say that Abuja, nothing is so special about Abuja. But the issue is not about not even about what is special about Abuja. The issue is that the Constitution in that section said 36 states of the Federation, 36 states of the Federation, and FCT. They didn't refer FCT as one of the states. They said and FCT. So you have to get that. But Tinubu and co, they are arguing that Abuja is like any of the states. It's not compulsory, you must get 25% there. And they are citing 299, section 299 of the Constitution. That's what they are using to sell their market on that. And you see how Peter Obi's lawyers destroyed this belief. And I hope that the justices will do justice to that. Now, going forward, they are looking at the judicial decisions that was taken in terms of section 134, subsection 2b, and section 299. They are now doing citations of cases. They said the Court of Appeal in Okoyode versus the Federal Capital Territory Administration in 2005 was invited to interpret section 299 of the Constitution on whether the Federal Capital Territory was a state, and in its decision stated that the Federal Capital Territory should be treated as one of the states in the Federation, in the Federal Republic of Nigeria. In essence, the question submitted to the court was whether the Federal Capital Territory Administration was an agency of the federal government of Nigeria. Now, the court in answer stated that the Federal Capital Territory Administration, that's FCDA, was an agency of the FCT, which is a separate unit from the federal government. and should rather be seen as a state and a separate administrative unit, distinct from the government of the Federal Republic of Nigeria. Now they move on to the case of Panya versus the President of Federal Republic of Nigeria in 2018. And it's also instructive, according to them, that the issue submitted in that case was whether the indigene of the Federal Capital Territory, Abuja, FCT, are entitled to be appointed as ministers of the Federation. Here, the court cited provisions of Section 142, 147, which states that ministers shall be appointed in line with federal character, and that all areas and states of the country, ought to be evenly represented in the ministerial list. The plaintiff argued that the FCT, for the purpose of appointment of the executive, is a state, and the appointment of persons as ministers ought to reflect federal character, which includes appointment of indigenes of the FCT. The court agreed with him to the extent that failure to appoint indigene of the FCT is a violation of the constitutional rights of Section 147, subsection 3, and Section 299 of the Constitution. Going further, the Obi's lawyers, still on this Section 299, said that although all these cases touch only on Section 299 of the Constitution, none of them interpreted Section 299 together with Section 134, subsection 2b, and that they cannot wholly guide the interpretation of the provisions as it is the law, that a case is only an authority for what it decides. They also mention must be made of the decision of the Supreme Court in the case of Awolowo versus Shagari, where the court had the opportunity in interpreting the provision of Section 34A 1 and 2, which reads that the winning candidate into the office of the president must have not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the federation. But this citation of Awolowo and Shagari is also one of the things that Tinubu and co are citing, and those who support them are citing, to say that the matter had been settled since 1983. It's not true. It's not true, because at that time, Abuja was not added into the picture. Abuja was not added into the picture. Abuja was added into the picture in the 1999 Constitution. Now, going further, Obi's lawyers contended that the provision of law interpreted in Awolowo's case is different from the one being considered here, as it has an additional requirement for the FCT. The decision is not quite helpful for interpreting Section 134, subsection 2b, and Section 299 of the Constitution. They were absolutely right. You can't use this Awo and Shagari issue to compare it with what we have now under the 1999 Constitution. Awo and Shagari, their issue was addressed in the 1979 Constitution. We know that there were so many things that was copied from 1979 Constitution into the 1999 Constitution, but they were not the same document. Going further, the lawyers of Peter Obi submitted that a purposive reading of Section 134, subsection 2B of the 1999 Constitution and Section 299 and the remainder provisions gives the conclusion that obtaining 25% vote in FCT is an additional standalone requirement for election into the office of the president, or the FCT is only a state together with Nigeria's 36 states where the winning candidate must have obtained at least 25% in two-thirds of all 36 states, meaning that Abuja will join and become 37th state. And we know that Abuja is not the 37th state of Nigeria. The Constitution listed the states of Nigeria. Just as the Constitution listed the local government. You know that the local governments of Nigeria are about 774, is it 776? I'm not very precise. All of them were listed in the Constitution. That was the problem that Obasanjo had with Tinubu when Tinubu was governor of Lagos State. Tinubu went and created local government. Obasanjo refused to release the money of local government to him. And people were saying that Obasanjo was playing bad politics. It was not. Because the Constitution listed the local governments in the country. Tinubu went and created area council, area development centers or something like that. And Obasanjo refused to release the money. Relying basically on the local government that were listed in the Constitution. And all the states in Nigeria are listed in the Constitution. And if you go to check that list, you will not see FCT as a state there. And we're a nation of laws. Okay? Now, continuing with Peter Obi and his lawyer's submission. They say that going forward, the Constitution in Section 299 has an interesting provision. It provides that the provision of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. However, the provision reads further that, and accordingly, all the legislative powers, the executive powers, and the judicial powers vested in the House of Assembly, the governor of a state, and the court of a state shall respectively vest in the National Assembly, the President of the Federation, and the courts, by virtue of the foregoing provisions, are court established for the Federal Capital Territory, Abuja. So this same section they are quoting to equate Abuja to be a state, they reminded Obi and Tinubu and co, and of course the justices, that this section did say that legislative power, the executive power, and judicial power, which ordinarily are vested in states. In the case of Abuja, they are vested on the National Assembly. National Assembly makes law for the FCT because FCT does not have State House of Assembly. The President of Nigeria is the governor of FCT because FCT does not have a governor. The judiciary in the federal system, federal level, superintend over the FCT courts. So you can see clearly, even the Section 299 did not arbitrarily equate FCT as a state. From this, you can see that FCT is different from other states. And I think Peter Obi and his lawyer, they presented this thing so eloquently. And it's interesting. Okay? Now, going forward, Obi and his lawyers, they said that the quagmire, which has formed the fulcrum of popular debate, lies in resolving the simple question: what does the Constitution contemplate having regard to the deployment of the word and, before mentioning the Federal Capital Territory, in the context of the constitutional calculus? In other words, is it within the contemplation of the Constitution that the Federal Capital Territory can be jettisoned in any constitution, in any construction of the words of the Constitution, aimed at determining whether the winner of an election into the office of president can win the states and forfeit the FCT? We think not. Peter Obi and his group and his look at him, they say no, that the contemplation of the Constitution is not that you can become president by virtue of getting 25% out of the 36 states and they ignore Abuja. They say that is not the intent of the Constitution or the drafters of the Constitution. Now they continue, they say at this juncture, we must call in aid the dictum of they cited Udoma, Justice of the Supreme Court of blessed memory, who said that, my lord, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism. I do not conceive it to be duty of this court so as to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction equally in accord and consistent with the words and sense of such provisions will serve to enforce and protect such proper ends. Continuing, Peter Obi and his lawyer said that once this purpose construction is employed, it will seem obvious, in our view, that the beneficial construction of the word "and" will be the one that ensure that "and" placed between the states and the Federal Capital Territory in Section 134 is construed as conjunctive and not conjunctive. Citing again Buhari versus INEC. Buhari versus INEC in 2008 also. Now, moving forward, now looking at Section 299, the one that Tinubu, all these Femi Falana who are support claiming that Abuja, there's nothing special about Abuja, that Abuja is no different from the states. This is where they finish that argument off. Now, they say that the argument that Section 299 of the 1999 Constitution, as amended, provide that FCT should be treated as a state is presently misplaced. Okay? They say that Section 299 of the Constitution is contained in Part 1, Chapter 8 of the Constitution, which only deals with allocation, legislative, and executive powers for the internal administration of the FCT, basically demarcating FCT administration from the federal administration. Now, let me explain this. This section where you have 299, this 299 is in Part 1, Chapter 8 of the Constitution. That particular chapter, if you go and look at our Constitution, you see there are different chapters that deal with different issues. This 299 was addressing the issue of internal running of FCT in terms of allocation, in terms of executive powers, in terms of legislative powers. It was not talking about the election. It was not talking about election. It's just like now, if you want to look at disqualification of Tinubu, you go to section 137, which deals with a chapter of the Constitution on conditions that will be used to disqualify a candidate. What section 134 contains is the chapter that contains how to know who won the election. It has nothing to do with 299, which has to do with administrative purpose, allocation of resources, legislative issues, internal running of the FCT. So it's a very brilliant presentation by Obi and his lawyers here. Okay? Perhaps let me repeat it again. He said the argument that section 299 of the Constitution as amended provide that FCT should be treated as a state patently misplaced. Section 299 of the Constitution is contained in Part 1, Chapter 8 of the Constitution, which only deals with allocation, legislative and executive powers for the internal administration of the FCT, basically demarcating FCT administration from the federal administration. This section see as they explain further the difference between the two and the reason why the court, the justices cannot use these two at the same time in their interpretation of whether FCT, getting 25% in the FCT is compulsory or not. Let us go further. He said this section 134 of the Constitution is in chapter 6 of the Constitution. It's in chapter 6 of the Constitution. Now, by section 35 of the Constitution, every provision is part 1, chapter 8 of the Constitution, such as section 299 of the Constitution, concerns only matters covered by that part. Now, what I am saying here is this. Every section you see has a chapter under which it rests. That particular chapter, what it says it addresses is the matter that you can use it to address. You cannot go and use 299, bring it to interpret the issue of whether FCT, you need 25% in Abuja. Where you go and interpret it is in section 134, in their own chapter, separate from the chapter where you have 299. That is, they cited the law, the Constitution, to show that. I think it's a brilliant presentation, as far as I'm concerned, to convince the doubting Thomases. And this, as far as I'm concerned, I don't know how the Tinubu will get away with this. I don't know. But we all are waiting to see what they will say. Now, going forward, in their final submission, they say, it is therefore submitted that the provision of section 134 cannot be interpreted with reference to section 299 of the Constitution, bearing in mind the provision of section 35 of the Constitution. This section 35 of the Constitution is saying that you cannot go and equate different chapters when you are dealing with matters that concern different sections of the Constitution. So you cannot, therefore, go and bring the matter of section 299 as Femi Falana, as the Tinubu lawyers, as Ahmed, and the APC have done. It doesn't work that way. So it's unambiguous. You have to rely on the statement, intendment of the law in section 134, subsection 2b. And it is written in plain English, as Peter Obi and his lawyer have shown. And the Supreme Court have ruled that that and is conjunctive. It is not optional. You must get 25% in the Federal Capital Territory, Abuja. I believe that by this presentation, Peter Obi and his lawyers did justice in convincing any doubting Thomas that indeed 25% is compulsory for anyone to be declared the winner of a presidential election in Nigeria. Thank you for watching this video. And if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. Thank you, and God bless you and yours.